So Crossroad 1 covers 4 different aspects. Each ESR is responsible for one topic. So I'm ESR1, and my work is to explore the reflections of the European data protection regulations onto computation dynamics, with specific attention to the relevance of personal data for the purpose of market dominance. And Tommaso is ESR3. He studies the definitions of a regulatory framework regarding data possibilities, explores the relevant legal and technical tools for the data possibility to be drawn not only for the GDPR, but also for the other laws. And Matisha's dimension focuses on the junction between privacy preserving requirements under regulations, established industry practice focused on the perceiving privacy, as well as emergency technologies, which further strengthens the data protection rights of data subjects. ONG tries to find the identification of quasi-property models to address conflicts between data holders and data exploiters. In light of the mapping between different interests related to different information assets.
And just very in general, according to this sphere theory, different types of spheres, for example, the public or private sphere of an individual existed and were worthy of different levels of protection. But this sphere theory was later abandoned with the famous ruling by the German Constitutional Court in 1983, because it was no longer believed to be capable of adequately protecting the right to informational self-determination, because ultimately, I think also from data that is believed to be non-personal or non-sensitive, you can infer very sensitive information about an individual. So this then again, I think relates very much overall to the LEADS project, which is all about this dialogue between lawyers and computer scientists and to find adequate solutions in data governance.
Gradually, people find that the data itself holds many kinds of values, such as privacy value, information value, and network effects. And it also has so many impacts on different areas, like the behaviors of different market players, data versus trade secret, we have already mentioned, copyright and artificial intelligence. So it is very hard to put data or personal data protection in private area or public area. So all we can't regulate it by a single law or a single regulation system. So consider it data often requires coordinated regulations in multiple areas. So that's why they switched the theory. So I think maybe this is a reason, but it's part of it.
And during the first report, I looked into debates of how data property or how the introduction of data property rights might solve some of those tensions, for example, because it was believed to empower individuals with regard to their data or to facilitate the emergence of data markets. But since now the idea of property rights in data has been abandoned by scholars and policymakers, still the questions remains, like if property rights in data don't work, which tools do we have at our disposal to realize these EU policy goals of facilitating data access and data sharing? And this then led, for example, in my case, to the evolution, or also in cases of the whole Crossroad, how did we look into different forms of data ownership? Yeah, by looking, for example, into data commons and how technology like federated learning might facilitate the creation of data spaces where data can be accessed, but without infringing privacy or economic interests in data. And yeah, this development then clearly shows how our perception of data governance evolved from creating exclusive rights in data towards facilitating data access and data sharing.
as a regulatory object, now we start understanding why is it hard to regulate data. Because it's completely interlinked with the idea of information and information that it conveys. So again, distinction between data and information is essential for comprehending data governance. And if you go back to the ways in which we started basically dealing with the problems with data and the protection of personal information, most of all, if you go back to the 1970s, where in the US they were discussing the Fair Information Practice Principles. Back then, the principles that were discussed then were based on a technology which was kind of simple. It really looked just like a CSV file. There was no big data, no IoT, no connected cars, and the capacity for analysis was very limited. However, the evolution of the technologies around data and its analysis has outpaced by a magnitude of times, by multiple times, let's say the way in which the Fair Information Principles was dealing with this data. And so has the evolution of data protection laws worldwide are largely adhered to these principles, and same has gone for IP in the sense of inventions, creations of the mind, business secrets, software code, and so on.
And because I think one of the overarching challenges of our Crossroad relates to the very general questions: how can we resolve conflicting interests in data in a regulatory environment that wants data to be as open as possible and as closed as necessary? Because as we know, the EU currently tries or wants the data is accessed, is shared to as widely as possible. But at the same time, we have different stakeholders who do not want their data to be accessed and shared, for example, due to privacy interests or due to interest in trade secrets or intellectual property rights.
From a privacy preserving and intellectual property perspective, our first report was focused on identifying how data is going to flow, what kind of privacy preserving mechanisms we have to undertake in order to ensure that we are focused on upholding the right to privacy, but also the fundamental right to conduct a business and honor intellectual property rights that organizations and individuals hold. But as we move into the second report, which was concluded after we did our working papers, which was another set of assignments, we saw a lot of interesting nuances open up. For example, we also included now in our Crossroads the effects of using data under artificial intelligence programs to carry out various sorts of like business analytics or like churning of large volumes of data for a competitive edge by businesses. So that was definitely an interesting dimension that we also added to the second report, because as we know that the AI Act is, the discussions and the proposal and the legislative process is under full swing. So we are set to see some sort of major overhaul when it comes to the tech regulatory landscape.
Now, there is this interplay of challenges and opportunities, those in data governance. The way in which one can protect data by not sharing it is kind of simple. Like if I keep my personal data under my control, then I just don't have to share it, and I'm protecting it somehow. The same goes with information that relate to business aspects, so trade secrets. The moment, though, in which data and information crosses this line of secrecy, then we all have to basically rely on trust on others for it to be protected, be it a government, be it a, I don't know, maybe other business partners, be it people that we trust. So trust becomes crucial, and that's why it is so hard to regulate data.
I think the fulcrum of this report for us was that we wanted to create a relevant piece of work for both academia as well as industry, so that the balance between practical interests and theoretical principles was something that we work towards carefully curating, since we understand how crucial both data, privacy requirements, competition requirements, and IP rights are to all stakeholders involved. We wanted to have a really balanced overview between theoretical and practical implementations. We also tried to keep in balance the economics of it all, from the competition law perspective versus how like the data economy has been thriving, and so on and so forth.